the Whistleblower House. Cynthia is a renowned South African whistleblower. She's now the Executive Director of Whistleblower House, and her objective now is to promote the dignity of whistleblowers. She was also the whistleblower in the South African Airways matter, and you can read all about it in her book, Hijackers on Board. And then we've got Masauso, the Executive Director of the Center for Ethics and Public Integrity, Zambia. And as you all know, Zambia has become an absolute shining light in the SADC region on a president who's promoting good governance, and we're very happy to hear from Masauso this morning. He comes from the public sector, having worked in the Anti-Corruption the Anti-Corruption Commission, as well as the Zambia Revenue Authority. I'm sure he has lots of stories to share with us about that. And now he works for civil society. And then we've got Zunaid Lundell from LHL Attorneys. Zunaid has been described as the attorney who has consulted and represented the most whistleblowers in South Africa. And he's going to be looking more at the legal framework and also around corporate governance. He consults with clients both in South Africa and in the US. So we have a very esteemed panel this morning, and we'll kick off with Cynthia.
Thank you very much, Chantelle. So today I'm basically going to talk about just my story and how in me trying to highlight corruption, I was then victimized and subsequently suffered the type of ostracization, vilification that most whistleblowers suffer. So in my role at SAA, I was the group treasurer, and it was in that role when I spoke out about pending corruption about to happen. So the first step was that I was called in to ratify a board resolution. A decision was taken at board to bring in a client that did not go through the request for proposal process. So that immediately is a red flag. So in corporate governance or any area we're working in of compliance, we need to follow our policies and procedures within our organization. And so I refused to sign this, and I said, no, we need to go the proper route of going through the request for proposal, bring this person on board, and then resend the proposal out. The second time I was called in was that I should then change the suppliers of the funding that we have, that SAA goes to seek for funding. Now, as a normal citizen and a normal organization, you go for funding at a bank. You do not go to a small organization, and neither do you go to any consortium. In this case, they wanted to bring in some other suppliers, which again was against our policies because we had a credit risk policy which stated we needed to only go to banks, and banks were credit rated specifically for this purpose. And then our board bypassed my division completely and excluded me and decided to get a transaction advisor via the procurement department. The transaction advisor, when they put out this request for proposal, was that this transaction advisor was going to review our loan book, which I was in charge of as Treasury. They were going to review our leases, the aircraft leases in SA, and they do have a department who does that and reports on it regularly. And the other part of the mandate was that they have to look at our balance sheet and see how it can be restructured, which our finance department, together with internal audit and external audit, looks at. And then the last thing was review expensive loans, which we do on a regular basis, that as soon as we see interest rates are changing, etc., we advise our board, we advise the executive. However, this client was chosen on this mandate just to do review work, and the cost was 2.6 million. However, once the client won the contract, our board then wanted to change the scope of this contract. The scope then was that the client now sources funding for SAA, and the cost for them sourcing the funding was going to be 256 million rand, R250 million. It's work that myself and my team in Treasury do at the cost of our salaries, and therefore not adding any additional cost to SAA's cash flow. But this is the route they propose to go. I tried to stop it. I was away when I was first called in to sign the change of mandate and the scope, which I refused. So I said, I'm not doing this. My scorecard, my balanced scorecard and KPI says that I must save 300 million for South African Airways. And now, if I sign this, I'm wiping out what I'm trying very hard to save. And I was told, okay, we'll discuss this while I'm away. However, this deal went ahead. It was signed by my deputy while I was out of the office. When I got back, it was actually pushed forward to the bid adjudication committee, who signed it. When I reviewed when I got back to the office and looked at the minutes and looked at who was sitting on this committee, not a single person asked any questions. They didn't ask why we're doing it, why we're pushing it. Suddenly, why would we pay such a huge amount? Nothing was interrogated. So again, one sees that when you're in a senior role in your organization and you're just signing off because people are telling you to sign off and you're not interrogating it, it shows what role are you playing then? Are you doing your due diligence? Are you being an active corporate governance citizen within your organization? So when I saw this, I then decided I have to report this to my executive, which I did. I took it to the chief risk officer. I took it to the chief audit officer. The chief audit officer said, well, the only option I have is to go through the internal whistleblowing reporting line in my organization. But he said, we're busy with it. We're changing the portal. I took it to the chief strategy officer as well, the executive, and he said, don't report it in the internal hotline, but rather report it to National Treasury, which was SAA's shareholder. So that was our structure at the time, which I did. Having reported there, I heard nothing. This was the full board then signed this transaction after the bid adjudication committee, and they signed it via round robin. So they approved that a transaction advisor now takes the responsibility of seeking funding for SAA of 15 billion rand at a cost of 1.5% on the total quantum, making it the 225 plus VAT. At the time was 14%, making it 256 million. And our board passed it. When I contacted the company secretary to see if I could attend this board meeting, that's how I found out that it was already approved via round robin. Yet, a week later, the full board was going to be sitting. And they chose to do this prior to the board meeting. So that just showed to me that they were determined to get this deal going. And for me, my thought process was only that this is against our governance processes within, our internal policies and our level of reporting, because it's not going through the normal channels. And so I wrote a formal letter and I put all the documents together and I sent it to National Treasury. I heard nothing in June, so I then contacted the same executive that I initially spoke to and said, well, here's another organization, speak to OUTA. And I spoke to them. They immediately took my evidence, and which I gave to them on a Friday the 1st of July. That weekend they worked. By Monday, I had a second meeting with them at 6 o'clock in the morning, and they said to me, well, we established that BNP Capital does not have an office. They have its address listed in Sandton, but the company did not exist, and that they did not have an FSB license. So on that basis, obviously knew something I didn't know of, but I just knew they were transgressing our internal policies. By the 5th, word must have got out that I'd also reported to National Treasury, and I was called in and suspended. So that's where I'm going to leave it. This is what happens to whistleblowers, trying to do the right thing, and then before you can even speak about it, you are then stopped. So I normally use the analogy that when you're watching a soccer match and that referee blows that whistle, what happens? The players on the field all pay attention because they need to see who was offside or who was foul. Secondly, the spectators all listen because you want to see what's happening. Why did they stop the game? And you're all listening. But when a whistleblower, as we are our term, blows the whistle, we are gagged. They try to stop us from speaking. They try to withhold the information or twist the information that we are speaking about, or they try to make us completely non-existent. So we become the pariahs of society. We become the people that nobody wants to listen to, engage with. They make sure that the entire organization doesn't speak to you. When I was suspended on the 5th of July, a company memo went out via email to everyone, and SA's officers all around the world, stating that I committed financial misconduct. Yet my letter stated until further investigation, because they had nothing else to find out about me. So this is the way they then vilify a whistleblower and stop them then from anybody trying to engage. What transpired too with my case is that even though I went through lawyers, it went through the Labour Court Rule Act process. So I had to go, my lawyer, we first went to the disciplinary hearing, SA didn't pitch. My lawyer then said, we're taking it to the Labour Court. We said, we've got to take it back to the CCMA. And for consecutive months in a row, almost a year, SAA did not attend any of the CCMA, so we had to postpone. So it was my time, my spending time with my legal counsel, my racking up bills to pay the legal counsel, and nothing transpiring. In the end, my lawyer advised me to just walk away. You're about to, not walk away, but he said, you're 59, you're about to take it's close to retirement, let's see if we can engage sort of a separation agreement. Well, it was more early retirement, that's what we signed. So I had to walk away, but I didn't sign any non-disclosure agreement that I couldn't speak about SAA. My family and husband and children and siblings were all saying, get on with your life, focus on a different way of tackling this. And that's how I got out of the SAA space. Obviously, when people think you're signing an NDA or a settlement, my settlement was literally 6 months' salary, which I would have got at the CCMA. But just going from there is that many whistleblowers walk away with absolutely nothing. They lose their credibility. They lose their reputation. And it's far harder for you now to fight back from the back foot because you've got nothing. You've lost from a financial perspective, you lose because you haven't been able to, if you haven't saved enough funds, how are you going to pay those legal fees? And I was fortunate that I had my family backing, saying that they will help me get the best lawyer and they will help and support me through the process, which they did. A second pillar that supported me basically was my own faith that I have in God. And my third was probably just having a routine of being active, of running daily or doing yoga or meditation, and that kept me sane during that time when you feel people were ready to stab you in the back, were willing to do anything to ostracize you. So my story is also a reflection of every other whistleblower story, in that some get so depressed that they become suicidal or actually do commit suicide. Others who stated. So our country is rife for not at this point supporting whistleblowers to the hilt as they should be, because as Judge Zondo stated in his report, was that whistleblowers are that last defense fighting against corruption, and we should really be supporting them and ensuring that the legislation supports them. Thank you. I'll end there.
Thank you, Cynthia. I mean, I know we're talking about collective action this morning, but I mean, Cynthia's just painted an incredibly lonely picture where if it wasn't for your family, you would have been completely alone on this. So, Masauso, if I can hand over to you now to share the Zambian experience.
Yeah, thank you very much. And that's a very touching and interesting story on how a whistleblower in the name of Cynthia was treated. And I think the whole essence of whistleblowing is to prevent corruption and any other malpractice, and to ensure that wrongdoing, corruption are brought to the fore. Whistleblowing is very, very important. And we should take it very, very serious, and whistleblowers should be protected from all sorts of victimization or retaliation in whatever form. But the questions do arise. Where do we blow the whistle? Where should we blow the whistle? And in this era of social media, do we blow the whistle on social media? Do we go straight to the mainstream media and blow the whistle there? Where should we blow the whistle? Or do we go to law enforcement agencies? That's very, very interesting and very, very...
And that's something that I think I learned while I was abroad in the US. There's a lot of collaboration that happens amongst attorneys, philosophers, ethics professionals, government agencies like the Securities Exchange Commission, the CFTC, which is the Commodities Future Trade Commission. And there's a lot of robust debate that always happens, and you get invited to events like this to discuss and debate and see how, as a collaborative effort, you can help to protect whistleblowers, because the late Kofi Annan said, you know, if corruption is a disease, transparency is one of the most important ways to treat it. And the important thing thereafter is that whistleblowers are at the front line of that corruption. They are probably the first people who have the courage to speak up about that corruption and shed light on it. And I think what I'd like to talk to you about, and this is quite particular to the South African legislative framework, is how we looked at legislation in South Africa and adopted certain strategies that we think will work in our constitutional democracy. So we have, obviously, the Constitution, which was enacted in 1996. It was sort of regarded as one of the most progressive constitutions in the world. And one of the important provisions in the Constitution is the Bill of Rights, sections 9, 10, 16. I think section 23 speaks to fair labor practices as well. Section 10 speaks to the right to dignity. And section 9 speaks to equality. There's also section 16, which I think speaks to the security and integrity of the person. So we need to give these types of provisions in the Constitution flesh. We need to give it meaning in our society. And judges and justices can't go to the public and say, well, this is interesting, come bring your case, let's write a judgment about it. They rely on progressive attorneys to take these types of matters on and think creatively about the law. We are a young democracy that has a raft of legislation at our disposal that we can use creatively to protect, uphold, the plight that whistleblowers are going through, but more importantly, beyond that, the scourge of corruption that we are faced with after the past 10, now maybe 14 years that we've experienced such blatant corruption. And what came out after the State Capture Commission, which was a commission set up by the government to investigate corruption in our country, was shocking and alarming. And it just shows that this was one commission into state capture. We'd had previous commissions into SARS, the South African Revenue Service, into other state functionaries, but this by far was the largest, and it was chaired by the now Chief Justice Raymond Zondo. And coming out of that there is a lack of protection for whistleblowers. Whistleblowers don't have the means, financially, emotionally, and from just a navigating the law perspective on how to blow the whistle, remain protected, remain anonymous, and be able to have what they've blown the whistle on addressed. So we've touched on the Constitution. That's the first part. The second part then is the Protected Disclosures Act. So the Protected Disclosures Act in South Africa was enacted in 2000. There's been an important amendment to the Act, which came about in 2017, which expanded the definition of employee to any worker. And I think the important thing there is that it's not just any worker, it could be anyone who is being in some way remunerated for servicing the company. And that's in the Protected Disclosures Act, it's in the definition section, section 1. And I think that there were a few other amendments that were very critical as well that came in. But importantly, the Protected Disclosures Act does give a whistleblower the ability to blow the whistle and seek recourse not in the labor courts but in the civil high courts. And I feel like we haven't seen enough of that, and we should start to see more of that. There should be a way in which attorneys who have been faced or are consulting with whistleblowers be able to use the courts in terms of urgent court proceedings. And if you can get around the case for urgency in the courts, you can then bring an urgent application. And in terms of the Protected Disclosures Act, I think it's section 6, if I'm not mistaken. I may be wrong, but one of the provisions in the Protected Disclosures Act provides civil and sort of occupational detriment immunity to a whistleblower who has been adjudicated or has had a judgment or an order or an award confirming that that person is a whistleblower. Because what you also don't want is to have sort of shooting from the hip type of people who are just sort of claiming that they're whistleblowers but not doing it, and this is a requirement in terms of the Protected Disclosures Act, doing it with a reasonable belief and in good faith. And I think that's also very important if we want to maintain the integrity of the role whistleblowers play in our society. Reasonable belief and good faith. Those are two legal concepts that a whistleblower doesn't necessarily understand as a layperson or not as a legally trained individual. And we've had to, as lawyers, read into case law, what does reasonable belief mean in the circumstances of a whistleblower? What does good faith mean in the context of a whistleblower? And we've had to look at case law, and there is case law out there that speaks to those two provisions in the Protected Disclosures Act. There's a Supreme Court of Appeal decision, a couple of Labour Appeal Court decisions, and Labour Court decisions that speak about this. Moving on from the Protected Disclosures Act, when we're looking at it from a whistleblower perspective, well, let's just touch on one more provision. I think Masauso asked a very important question: to whom do you blow the whistle? To whom do you make a protected disclosure to? Remember, it's a disclosure. It only becomes protected if it meets the criteria set out in the Protected Disclosures Act. Is it reasonable belief, and is it made in good faith? And then, is it made in terms of Section 5, 6, 7, 8, or 9 of the Protected Disclosures Act? Section 5 speaks to making a disclosure to attorneys or to a lawyer or to someone providing legal services. That's important. And I'll get to another question: is how do we ensure whistleblowers are protected? Section 5 for me, and through researching and dealing with consultations with whistleblowers, you often find that they're up against so much power and so much might, financial might, just blatant aggression and the psychological trauma that they face. It's so difficult for them to blow the whistle and remain clear-minded, focused, and know how they need to blow the whistle and not receive the reprisals they do from their very own government functionaries for blowing the whistle. So whistleblowers can make a disclosure in terms of Section 5 to an attorney. In terms of Section 6, that's to your employer. And there are certain ways in which you need to make a disclosure to an employer. Section 7 is to certain members of cabinet or certain ministers. Section 8 speaks to making a disclosure to certain Chapter 9 institutions. The South African Human Rights Commission is one, the Public Protector, and a few others. And then Section 9 is a general disclosure to the public. And that's what we advise against. Do not make a protected or disclosure to the public. It is probably going to come back to bite you. And if you're operating in the listed space, I know Andre Visser was here earlier. I had the pleasure of working with Johan Lutsky, who passed away earlier this month. He was very much involved with the Johannesburg Stock Exchange and listings requirements and actually setting up a couple of other exchanges. And the important thing about blowing the whistle to the public in the listed space is if you've blown the whistle and the conduct with which you've done it doesn't meet the criteria of good faith and reasonable belief, you may be sued by that company for a diminution of the share value because people react in capital markets to what people say in the media. And I think that's very important. Don't seek the attention, don't shine the spotlight on yourself until there's a strategic approach that's been developed by an interdisciplinary team. And that's why I enjoy working with the Whistleblower House, because they've been at the coalface of actually blowing the whistle. So I often go to them for advice on, how do I treat my whistleblower from a very sensitive perspective? What are the psychological elements I need to be aware of? What do you think they're feeling? I need to understand that in order to properly consult with my client. And we also work with the Whistleblowers of America. Jackie Garrick just wrote the first book in the world that really speaks to the psychosocial trauma that whistleblowers face after blowing the whistle. And she's really done an incredible study on this, and she's trying to get more and more people to understand the psychosocial draftsmen and women drafting that act. And if you look at Section 1, let's start with Section 5. Section 5 says you need to interpret the Companies Act in line with the Constitution. Okay? That's very important. So as you interpret the meaning, the purport, and the objects of this act, the Companies Act, determine it in line with the Constitution. Section 7 speaks to the fact that you need to ensure that the interpretation of this act is done in a way that is not only focused on shareholder profit maximization, which is an element that I have views on and we could talk about for hours, but it should be interpreted on the enlightened shareholder approach. The enlightened shareholder approach looks at a multi-stakeholder view where the duty of directors is not only to maximize shareholder returns. And if you have that type of approach like they do in the States, if you have a shareholder maximization approach, you can justify that you are maximizing returns to your accountable stakeholders, investors, or if you executive management to your board, and say, well, we managed to maximize shareholder returns, but at the expense of your employees, at the expense of the environment, at the expense of your community. And the point there as well, and I think it was touched on the previous panel, is oftentimes you have multinationals coming to Africa and these extractive industries that they're involved in. The shareholders sit in the US, in Europe, or in Australia. They're operating in Africa. And if their legislation says, well, the duty of directors is to maximize shareholder returns, what do they care for about the people who are working on the ground extracting those minerals for the benefit of those shareholders? What do they care for about the environment in which those mining companies operate in? Which is why I think we need to have more discussions in South Africa about the enlightened shareholder approach and ensuring that self-regulating regulatory organizations like the Johannesburg Stock Exchange through the King Code, King 4, really start to impose this and not just sort of cordon it off to the ESG index, but make it mainstream and say, well, you know, the duty of directors is not just to maximize shareholder returns. So the Companies Act, Section 5, Section 7, and then Section 159 is titled Protection of Whistleblowers. Many lawyers I speak to don't even know that that section exists. And that's actually quite frustrating because Section 159 is in many respects more progressive than the Protected Disclosures Act after its amendment in 2017. And we've researched this and we're actually utilizing this in some of our cases. First sort of knowledge that I have that Section 159 is actually being utilized in a case. And Section 159 actually is very powerful because I think it's Section 159 sub 4 reverses the onus of proof. So it basically says that the whistleblower, if it's made reasonably and in good faith, reasonable belief in good faith, reverses the onus. The company or the implicated institution needs to then prove why their conduct was not wrongful and why they were not at fault. So did their conduct breach a statutory duty, yes or no? Did their conduct, if it's listed, breach the listings requirements, yes or no? And I think that's very powerful. And then you've got a whole raft of other legislation. The Employment Equity Act, there's the Code of Good Governance that is an epiphenomenon of the International Labour Organization Convention 190. And the Employment Equity Act also speaks to, and we're looking at that quite critically, to see how we can interpret that act in a way that actually brings in whistleblowers as a protected category of persons in the Employment Equity Act. The Code of Good Practice is quite progressive, more progressive than the actual convention general descriptions. And then there's the PEPUDA, which is the Promotion of Equality and Prevention of Unfair Discrimination Act, which goes beyond just the employee-employer relationship. It goes to sort of anyone who commits any sort of discrimination. And I think that there's a moral discrimination where someone does make a protected disclosure and then is discriminated against and suffers occupational detriment. There you can see if we can sort of build the law. We're a young democracy. We need to add color to the legislative lines that have been drawn by the legislature. We need to be able to have precedent inform the legislation. That's how our judicial system and legislative system work. And we've had a lot of brilliant judgments, and I think in the Constitutional Court we have a very progressive bench that wants to see corruption being rid of, and that doesn't want to see corruption in our country or in the continent or in sub-Saharan Africa. So how do we create precedent for that? There's a few other provisions that I could speak to, but I think the other important thing is just to know that the Securities Exchange Commission, so we work with a law firm in the States, and we involved with Jackie Garrett from Whistleblowers of America, who I met through the Whistleblower House. The important thing there is if a company has a listing on an exchange in the US, so the NASDAQ or the NYSE, the SEC then has jurisdiction. The Securities Exchange Commission of the United States has jurisdiction over that company. You need to collaborate, if there are lawyers, you need to collaborate with the United States, with a lawyer in the United States who focuses on protected disclosure law, which is a huge industry there, and see to it that if there are any channels that can be opened up for the SEC to come in and investigate this, then the matter will be tried out of the United States. And then this law firm in South Africa will act as a correspondent attorney, giving it advice, doing the research, and building up the case with the law firm in the US. And I think we can learn a lot from the United States in terms of how they've been able to develop a strong plaintiff bar to litigate these types of matters. I think that's all.
Thanks, Zunaid. I think you've given us a lot that could really be used throughout the region with the enlightened shareholder. So we've got 5 minutes left for questions. Does anyone have any questions to our esteemed panel? Can we take two here in the front? Oh, okay.
Can I go?
Can we start? Yeah, you with the mic.
All right, cool. Thank you so much. My name is SAACoN Mbelase. And my question is really, there's a growing literature on social norms, right? Just looking into the role of social norms with corruption in itself. So my question is really, what is the role of social norms in how we respond to whistleblowers? We know that there's this whole idea of a snitch who will always get snitches, which people, generally believe in. So, and we also know that culture eats policy for lunch. So we can have all the policies that we can have, but they're not going to solve the problem. How do we collectively, and this is a collective action conference, so how do we collectively rally behind whistleblowers in terms of us supporting whistleblowers? If Musilo comes and say, I've whistleblown, how does the collectively, as the anti-corruption, community, rally behind that person in terms of support? Thank you.
Okay. I'm going to give over to Cynthia to answer that. Any other? Sorry, here in front, Musilo.
Oh, good morning. My name is Musilo Mutepu. I'm a state capture whistleblower, a patriot, a warrior, and a fighter, and author of Uncaptured. Cynthia, thank you. I would like to applaud you for your bravery. Many have seen wrongdoing, and they were too afraid. And I can say because of the gaps that your experience and many others, we've got the likes of Ethel Williams, who had to flee the country because of his whistleblowing SARS at Bain, and we have yourself and myself. From what I'm picking up is the actual experience on the ground, which is the occupational hazard, whether it's a victimization, it's being fired, it's lawfare, where you have to fight outside with your own money. And you've got large corporates who will essentially Stalingrad you until you are psychologically, emotionally, and financially exhausted. And then you have this wonderful constitution, this Companies Act. And the two, for me, they're not being implemented. For me, we talk about retaliation. I won't talk too much about my story because I have to speak, but for myself, it was as much as false, trumped up legal challenges for me. And you had a sense of there's no political will. Cynthia, congratulations on forming the Whistleblower House, because you identified the many gaps that we don't, as whistleblowers, face, and civil society nor government fulfill. Like, it's the legal challenge, it's the psychological. Thank you so much for raising that part. With regards to your family, yourself, having to, basically, it's David versus Goliath, but luckily in the Bible, David won. Hopefully, in many of our instances, we won. Silver, you've been vindicated. I have been vindicated. But I think what I would have liked to see the public protector there. I would have liked to have seen the Minister of Justice, Ronald Samula, there as well. Because we have been saying these are the gaps in the legislation. These are the Zondo Commission implementation recommendations. And we were supposed to have something in April, and we've had nothing from the minister. So we keep sounding like a broken record. And I say, but we have PLAF here, we have the Whistleblower House, but we also need companies, the JSE companies, and civil society and active citizenry to ensure that it's not a lonely, isolated, soul-destroying road. Because at the end of the day, this person has risked their lives, and they have bravery to expose corruption, whether it's in corporate or in government. And surely, as South Africans, we have a moral duty to support that person in any way they can. Thank you.
Thanks, Liesel Groenewald from the Ethics Institute and the Whistleblower House. Zunaid, in terms of Section 159 of the Companies Act and the Protected Disclosures Act, 159 places the burden of proof on the company, just like the EU Whistleblowing Directive, whereas the PDA is the opposite. So which one trumps in a court case? Thank you.
Are there any other? Okay, so this will be the last.
It's just a quick follow-up question to the one that Liesel just asked, which is, and putting on my lawyer hat, which is when 59 shifts the onus on companies. I don't think this happens, but if you confirm that it doesn't, then it's a good point for reform of that law or whatever procedural law. Can whistleblowers use that as a jurisdictional issue to throw out potentially retaliatory actions against them if companies have not complied with 159, which means Masilo blows the whistle on X company sues her while they have not yet done an investigation, because now the onus is on them. If, of course, her report is in good faith, established, can she then, in that action, potentially retaliatory action, ask the court to throw it out for jurisdiction, lack of jurisdiction, because they haven't complied with 159?
Okay. Cynthia, can you start off with the collective action question?
Yes. Thank you for the question. So yes, the term is there that, and the bad term of snitch, and in South Africa particularly, we have the term called impimpi, which is the person who goes and snitches on the other. And that came up in the early days, in the apartheid years, of when you see something, you go and snitch on them. To change that culture is difficult. For me, it's a moral issue that if I want to be malicious and I see Chantelle doing something like taking an extra bottle of water, which is really just an extra bottle of water type of thing, but I'm going to be malicious now and I want to drag a name in the mud, that for me is where we should be using the term snitch. But when one is looking at any wrongdoing, you've observed fraud or corruption, you saw money passing under the table, a brown envelope or something, you heard someone colluding about something, and you've observed it, and you have the evidence, and you're able to report that. We've got to get away from this where we are tattletaling on somebody or snitching on it, because we've got to look at the balance of what harm are we doing, firstly for the bigger interest of the public, versus just me being malicious against someone. And so, again, when it comes to reporting, that is why it's imperative that the whistleblower should not be the one that is shot down and victimized. There should be, in every organization, be it public or private, that they investigate the matter. Through investigation, you're able to establish whether this was someone being malicious and therefore the snitch, or this person showing there was evidence that there's true corruption or fraud going on. And remember that corruption is never one person doing it. I may steal this pen, I'm doing it and walk away, but if it's grand-scale corruption, it affects a lot of people. You can never get away. There's layers of people involved in the system for grand-scale corruption to take place. So if we're just looking back at what happened in our country with state capture, it cannot be one person. It cannot be the CEO or that one person. It was collusion. They got away because they could either coerce people to do it, force and threaten them or blackmail them on the one hand, or the other, they were participating in it gladly because they were going to get something out of it. So I believe that we in South Africa have to start changing, not only in South Africa, in the world, we have to start changing our mindset of how we look at wrongdoing and how we report it. They call them the old boys club. So what happens in the old boys club stays in the old boys club type of thing. So therefore, that's why things happen then. They don't talk about it afterwards. In exclusive schools, when you read about them, certain things happened, they didn't talk about it. That transparency, I think you mentioned, is important. Kofi Annan saying that it's with transparency you can start eradicating corruption. So it's important to start highlighting issues and bringing it to the fore and not look at it in a blinkered version that it's about snitching or telltale. So I hope I answered your question on that. And if I can just go quickly to Masilo's issue. Yes, I agree. We should have the people that are the decision makers on board and the enforcers in these type of forums. And whenever you need them, they're actually not around. And in the case of Masilo's case and Martha Ngoya, the legal system was used as weapons against them. So much so that it brings the whistleblower to their knees in trying to defend themselves. And so you have one part of the legal system which is there to protect every citizen and organizations because the law is in place, but then you have another part that's actually using the law as a weapon and then destroying that person's character, destroying their reputation. I'm going to leave it there. Thank you.
Zunaid, can you just answer those last two questions quickly? And can I just say you're very lucky to be getting free legal advice this morning.
Interesting question by Liesel, but Section 1591A basically says that the Section 159A must be interpreted in addition to and not in substitution of the Protected Disclosures Act. So you can use the best parts of Section 159 if you plead it that way. So you have to look at how you structure your case, how you draft your pleadings, your particulars of claim, or if it's an action, if it's a motion proceeding, your founding affidavit and your notice of motion. You have to plead it that way to say, in terms of this section, we electing to choose the reverse of onus because Section 1591A says that we can. And we looked at that as well in one of our first matters. And then the other question was just with regard to the jurisdictional point. It's a hypothetical that I think is difficult to answer, but what I would do in those circumstances is bring an urgent application to say, you cannot sue this whistleblower. We actually have prima facie evidence to show that this disclosure was made in good faith and with reasonable belief. This person must be protected and must enjoy the immunities that this law provides until a proper investigation is done. And often what we see is retaliatory investigations happen. Someone blows the whistle, then they start to investigate the whistleblower for some credit card payments that were done on the weekend and things like that. Whatever they can find, and I've seen that, and it's horrible. And then I think also the loss of hope in the law. And I think lawyers do have a bad reputation. I've had clients come to me and say, well, I've spent 1.2 million rand and they haven't seen the doors of court. Or I've spent 2.2 million rand and, we've just gone through to, there's been no resolution. It's been up and down. There are lawyers out there that act on contingency. And on contingency basically means that we don't charge a fee unless we win the matter. And some lawyers are willing to work on contingency. There are other ways of funding litigation. In one of the massive class actions that LHL ran, we had the litigation funded by a litigation funding house. In another class action that we're running, we're getting funding through American sponsors. And that assists the Davids, or whatever name you want to use. I don't know why it has to be David, but it assists the whistleblowers in ensuring that they have, because in law, you will suffer if you don't have financial resources and you think you can just do it on your own. You will suffer because you're up against people with incredible resources that will sue you left, right, and center. You don't know how to go to court. It costs money. But if you find a law firm and you find people that are willing to work together to find a solution and to participate on the upside, to say, well, if we win the matter, then we'll charge our fees, and those fees have to be disclosed and above board, and the court vets it. It's in terms of the Contingency Fees Act of this country. That, for me, is, and we've litigated at LHL like that for 35 years. That's the way we know how to litigate, because we've always represented marginalized or oppressed people. And I think that's definitely something that can be used. Your law can be weaponized against you, but if you have the right lawyers, you can pose, you can be a thorn in the backside of big companies, and the US has gotten it right time and time again. There's no reason why we shouldn't. We've got more progressive laws than the US does. We just need to have lawyers that are willing to stand up and fight.
Okay, so on that positive note, I'm going to wrap up because Scarlett told me now that lunch is ready. So please feel free to talk with the panel during your lunch break, and then we'll see you afterwards.